Right.
All right. Hey, everybody. Welcome to webinar, 1 bajillion. Gary is on his billionth wedding anniversary trip with Jennifer down in Kiwa. So congratulations. It is pretty seriously. I want to say it's probably maybe his 35th or 40th. I mean, whatever it is, it's a big one. So we're real proud of him for not managing to piss off Jennifer that bad for this long. that they
God,
that they
God
that
bless
they
her.
yeah, that they made it this far because I do firmly believe the older that I get, the more anniversaries that I celebrate are actually more related not to me. It's putting up with my BS. So thank you for that. Hey, Cameron, have not met you before, but nice meeting you virtually.
Think she's working on getting connected.
All
So
right,
yeah,
it's getting
no worries.
there. It's
Yeah.
getting there. I see some degrees on the wall. Is she also a fellow Carolina alumni
Well,
there,
maybe,
Jack?
maybe.
Yeah, maybe. Yeah, we're not inviting the Duke people back, for sure. Yeah. So anyway, this webinar's topic, if you tuned in and you don't want to hear about this, then make sure that you disconnect now. But we thought we'd spend the next couple weeks going back and forth on the top five, and it could be more than five, but the top five legal mistakes that small business owners make so that if we've made them, we can correct them. Or alternatively, we could be on the lookout for them coming up. And, Jack came up with his list. He asked for a special guest to join us from Shoemaker. She can hear me now, so she's smiling. Hi, Cameron. Haven't met you before live. Say
Yeah,
hi.
hi. Apologies for the audio issues. I guess my computer's used to Teams and not Zoom.
No, you're good. Welcome. As we always say on these, first time on a Zoom meeting. No, just kidding. Yeah.
Apparently.
Yeah. Anyway, there you go. So I'm looking forward to it. I did at least have the courtesy to send Jack my Chat GPT list of top five legal challenges in case he misses one. I now have the collective wisdom of the internet behind me, to address those, which I gotta tell you, we've talked a lot about Chat GPT on these meetings, and we hit it in a couple sessions ago that Jack found us a great panelist. If you guys haven't used it for brainstorming, it is an amazing brainstorming tool, and it's an amazing kind of aggregator of information that it would be hard to lie about. So just, dumb example, last night I was at the Cannonballers game, and I was asked, I wonder how old the players are. And, I just, as my wife pulling up the roster on Google, I pulled up Chat GPT. I'm like, I'll have this in about a second. What's the average age of the Kannapolis Cannonballers roster? 22.4 years, in case we're wondering. And it checked it, it told me which side it was referencing. So anyway, that was kind of a tangent. Current events, I don't really have any before we turn it over to Jack, other than if everybody could just stay calm. It would be fabulous. And I say that because Jack's laughing. I say that because as I was driving this morning, listening to the news, they were having somebody on Mike Collins. If you listen to Mike Collins on NPR, he's on at 9, Charlotte Talks. And it was someone that had written a book on hey Jim, you can try again. It was someone who had written a book on uh the McCarthy era. And what it made me think of was that just all seemed bad. Like if you watch the movie Oppenheimer, like that whole era just seemed bad, And so it actually just kind of made me thankful. It's like, hey, we're nowhere close to how bad things seem then in terms of like polarized, divided, you know. They talked about, a school teacher that got on a list who then the only job that she could find was cleaning poop at a dog daycare. And then she got fired from that too because they found out that she was on the list. It's like, yet I wasn't alive then. So I don't know. Like, I don't, I have no frame of reference for what that was like, but it just shows you, how relative, things can appear. So I'll stop soapboxing now and turn it over to you, Jack, if you got any current events.
Sure. So a couple things. First, I want to introduce Cam Householder. She is one of my wonderful team members in our corporate group, and was a summer clerk for us, and then came back to work for us. And Phil Chubb and I have not scared her away yet, so all good.
That's a testament. So you don't let her talk to Phil, is
Yeah,
what you're saying.
pretty
Yeah.
much,
Okay,
yes.
good.
Yeah. When I hear her coming, I like divert her from his office to mine because we're next to
Yeah.
each other. So yes. Um, and recently engaged, relatively speaking.
Well,
So yes.
congratulations.
I'm happy
Thank
for
you.
her. So a couple things. First, was reading that inflation hits the lowest level since 2021. So it got down to 2.9%, which is below 3%. And so there is anticipation that the Fed will, in fact, cut rates in September and bring them down a little bit, which has excited some people in thinking that, okay, now people who are waiting, they might be able to afford mortgages and borrow money and some other things. Business owners may be able to get a better rate on some loans and those kind of things. There was in the Business Journal, the Wall Street Journal, 5 big earnings season takeaways. And I'm just going to read them. Profits look strong. People are cutting back on the little things. And there was an example that even at McDonald's, people are buying less stuff or looking for the deals. High-end shoppers are economizing. So luxury watches, jewelry, clothes, the purchases that seemed endless not that long ago, even the high-end shoppers are taking a breather. We talked about the interest rates, and then big tech isn't letting up on its AI dreams. So, I was having a discussion with someone about types of stocks and whether, AI is the right way to go, and technology stocks versus traditional stocks. But I'm not a stockbroker nor a financial advisor, so I will not share my opinion on that. And then lastly, on current events, I think that we here don't bash millennials for the most part, but and generally speaking, I think millennials get bashed often. But when you see articles like I'm about to share with you, that maybe their method is getting rewarded for whatever they're doing, because there was an article in the Business Journal actually today. Millennials experience dramatic financial turnaround. And it starts out by saying millennials are now wealthier than the previous generations were at their age, which, I mean, I think that traditionally, if you were to look at the average income of individuals by generation, that's probably a true statement, just generally speaking, that the next generation, the average wealth probably increases for the most part, at least in the United States. And 15 years ago, Andy Holmes was a college graduate living with his parents, mowing lawns and digging ditches for extra income. He and his college pals, who could only get low-paid jobs, wondered if they would ever have a shot at success as their parents had. Today, Holmes is a chief financial officer in Kansas City, Missouri, on track to retire at age 52. This kid is going to retire like at 52. I'm in a place financially that I could not imagine coming out of college. At age 37, my net worth is closer to what I thought what it would be at 47. So, and the article goes on and continues to talk about statistics and everything else. So anyway, apparently, and I'm not saying this, the people who think that millennials are lazy and don't work hard, apparently they can retire at 52. So that's the message there. All
There
right.
you go. That's
There you
awesome.
There you go.
So Jack, how do we avoid making stupid mistakes?
Okay.
And everybody who's listening to this right now, here's what'll probably happen. You'll be like, yeah, I really should do that. And then you'll have the opportunity to actually do it. You'll go, oh, it's just so much work. I'll get to that later. And then you won't. And then all of a sudden you'll be paying Jack and Cam, 50 times. And I don't use that 50 times lightly. As a reference, pay them 50 times in expense
Yes.
relative to had you just done it right in the first place.
Yep. Yep. Yep.
So go, what do you got? What's number one? I feel like we're on Family Feud. Survey
Yeah,
says.
exactly. Well, I will tell you this, there's no particular order to the importance of this stuff other
Yeah.
than it's how kind of popped in my head. And then, so, and the reason being is, so we're going to talk about negotiating letters of intent, only because that's most recently on my mind over the past 24, 48 hours, which is taking the letter of intent process and taking it in a way that it's non-binding. And so therefore you can say kind of whatever you want, kind of make sure, throw yourself in the ballpark of things and then take the perspective that you're going to negotiate it at a later time. That is a really bad idea. Because there is, the LOI is an opportunity, even though it's mostly non-binding, to bring the parties together to make sure they're in the same ballpark. And that includes some detailed information, fundamental substantive information. So for example, not just what the purchase price is, but how it's going to get paid. Is it installment? Is it paid in full? Is there a promissory note? Is there going to be collateral? Things like, okay, is there a net working capital requirement? Adam and I went through this issue a few years ago with a mutual client as to, well, it really wasn't discussed at that time. And if it was something that was required, it should have been discussed at the beginning because it's something that would have changed the nature of the deal, potential the purchase price, potentially agreement on other issues, that there was this requirement to leave all this cash in the business. So things like that. So my suggestion to you, and it's a little bit self-serving, but it really isn't, is that you really need to bring your professionals, your legal professionals, and your accounting professional, your CPAs in on an earlier time period before you sign that LOI, because even though it's non-binding, I have many times, and Cam has, gone back to opposing counsel and said, well, that's pretty important thing that your client wanted, and it should have been in the LOI. So we're just going to assume that that wasn't as important, and we're going to continue to move on and basically ignore that until maybe the very end and use that as a negotiating tool to get something that we want on our end that maybe hadn't been thought about previously, or that had evolved in the deal that maybe, hey, these receivables that you say that you said were good receivables, maybe, and we were willing to say 5% maybe was bad debt kind of thing, or bad, were not receivables or not capable of being collected upon. So bad collections, that maybe that number is now 15, 20%. So now we renegotiate. So I just wanted to mention that because I've had to deal with that more recently. Unfortunately with our own client, but also on the other side saying, yeah, that wasn't in there at the beginning and you guys are changing the deal. So let's table that for now.
Yeah, it's actually funny to hop on that, just observing, our last couple transactions as well. As you were saying that, what it made me think about, Jack, and if you guys could kind of confirm, yeah, that's pretty much the case. If I think about, like, let's say I've got a $10 million transaction, right? And the working capital target is $1.5 million, $2 million, it's pretty typical, of a transaction that size, maybe it's 3 million. If you look at the amount of work, negotiation, diligence on the total transaction relative to that one component, it's almost like it's 50-50. 50% of it is like stuff. The other 50% is just arguing over, working capital, which is kind of unbelievable, when you think about it. But at the same time, it's like, look, I mean, what buyer wouldn't want to buy you using your money? which is really what it is, at the end of the day. So just curious to get your thoughts on that.
Yeah, absolutely. And I'll share kind of the experience that I was thinking about with you and me a couple years ago, and Adam was he was very gentlemanly and polite up until a point where he basically, it was an all hands call, I mean, the lawyers and the CPAs, and, it was a well-respected CPA firm on the other side. They were doing their due diligence, and and well-respected attorneys on the other side. And basically, so Adam stopped the train, basically said, you know what, this is coming down to you guys just wanting to be right on an issue that you're wrong on. So, you go back and tell your client that you're just, and I know he wanted to say you're being assholes, but he didn't say it because I wanted to say it. But you guys are just being adamant to be not to be that way and want to win a point. And then once you guys figure that out and your client tells you to get over it, then we can proceed forward. And the funny thing is that, and I don't know, Adam, if I think you know this, the CPA on the other side is a fraternity brother of mine. And
Oh,
so,
I didn't know that.
yeah, huh? And I was like, okay. And I did call him afterwards and I said, Adam's right. And he's like, and he didn't say, well, I won't tell you what he said, but he didn't deny that. So, so
Probably used him. He was so disrespectful and blunt, rough. So I think you forgot a few of the F bombs that I dropped in the middle of
yeah,
that too.
yeah. It got to that point where it was just
Yeah.
like, let me tell you what's really on my mind. So yeah, it does come down sometimes to the negotiation back and forth. But and some of that, even in that transaction, might have been avoided under certain circumstances if there was just more clarity, not necessarily in the LOI, but just and that's why, in that deal and in other deals, now I'm going way off on a tangent, things like having a sample of what the networking capital formula is going to be. So have a sample of it, apply the sample formula to the net working capital. So that way, when you do the true up 60 days down the road, it's exactly, the form, you're just plugging in numbers to a set formula so that, okay, our deposits part of the net working capital, is it a job that is going to be done the first year or is it ongoing? I mean, all these little things that kind of mess things up and lead to points of discussion, negotiation, argument, etc. So I want to move into non-competes a little bit just because it's a topic of discussion. And actually the effective date is September 4th for these new laws that come into play. But there are obviously appeals, and whether or not it's actually going to be implemented is yet to be seen, but we're close. I mean, we're less than a month away from when employers are supposed to be doing certain things and, non-competes becoming invalid. So let me kind of give you a little bit of background. We've talked about this before, but the ban on non-competes. So the rule is that the final rule prohibits an employer from entering into or attempting to enter into a non-compete clause with a worker, which includes both employees and independent contractors, which I also want to talk about a little bit later, that representing to a worker that they are subject to a non-compete clause. There are exemptions, which is non-competes for senior executives, which is essentially someone who makes over $151,000. And then there's a definition of what executives employees are, and it's based upon their duties that they provide to the employer. Okay, fortunately, this rule does not apply to someone who entered a non-compete in relation to the purchase of a business. So when a buyer wants to bench a seller and pay them money in order to bench them so they don't go open up a shop next door, those are still valid. And then you're not going to get in trouble. Well, okay. And then if there was a violation prior to September 4th, you can still enforce that the non-compete, the violation of the non-compete. You can't enforce the non-compete past September 4th. There is, let's say that you're an employer and you pursue an employee and you believe that they are exempt from the exception, meaning that it does still apply to them after September 4th, and you pursue that, and it ends up not being the case that they are not subject to the non-compete, then you're not going to get prosecuted for that. So what they're doing is they're trying to pursue or not allow for someone to be subject to prosecution for pursuing a non-compete after September 4th. And then there is a requirement for providing your employees knowledge that this is not going to be enforced moving forward. So again, as I said sarcastically in a previous webinar, going to your employers and saying, hey, remember that non-compete that you signed and I paid you extra money for? Never mind. And so that's essentially what is going to be required for employers. Now, as I said, the final rule is effective September 4th. And the reasons why people believe that this is not going to remain enforceable, meaning the ban on non-competes, is because, well, a couple of theories that they've exceeded their scope, both constitutionally and otherwise. And so first, there's this major questions doctrine, which is a rule of constitutional interpretation that Congress cannot delegate its powers for things that deal with vast economic and political significance. And if they do, they have to be very concise in what they allow the regulatory agency to do. And so it's undisputed that this would fall into that category, and that they really have not provided, Congress has not provided guidance, is likely a method for this to fail, or an avenue for it to fail. There is also the non-delegation doctrine, which says Congress may not transfer powers which are strictly and exclusively legislated to another branch. And so it seems like that's what they did. I mean, they transferred their legislative power to the executive branch through a regulatory agency. And then there is this deference to regulatory agencies that allow them to interpret things in between the lines. And there is the argument and the challenges that they've exceeded that. So I think that, and this is more of, we talk about the things that people don't do. This is one of those things that if you don't do, you might get in trouble, but hopefully that would be resolved by the end of the year. But it may take longer. It may take into the next year. So, what I can't tell you is what to do, meaning, okay, yes, by September 4th, or September 5th, you need to go do this or that. Because it really just depends, as most things do, on what the writing is on the non-compete. I will say that the restriction on non-competes does not apply to things like non-solicitation, to non-use of confidential information, unless it is a disguised non-compete arrangement. And so, we would have to look at that on a case-by-case basis. So again, September 4th, restrictive covenants on non-compete, but not non-disclosure clauses. It also doesn't apply to banks, savings and loan institutions, federal credit unions, common carriers, air carriers, foreign air carriers. And then if you're a person that's subject to the Packers and Stockyards Act. So I imagine that probably not for most of you. So, and then, as I said, executive officers with a salary range of 151, 164. Non-profits are not covered by the ban. I don't think it's because they didn't want to, but it's because the federal government, the FTC, does not govern over or impose its restrictions on the nonprofit arena. I don't know the basis for that, other than that's what it says. It only can they only have authority over for-profit businesses. And then there's at least 3 to 5 lawsuits being pursued in, I think, in Texas, maybe Minnesota, and maybe some other states that basically say, okay, this is not constitutional. The problem is that, similar to the Corporate Transparency Act, which I also want to talk about if we have a moment, is that it would only likely apply to those people who filed that lawsuit. So for us in North Carolina, South Carolina, and other places, not applicable unless the Supreme Court gets involved and they say, you don't have to apply, you don't have to comply with it at this point. So that is more of a prospective mistake that you might make if you don't comply with this, but I can't in this moment tell you to comply with it, other than the fact that there's a September 4th date. Maybe in, the subsequent weeks, the next 2 weeks or so, we'll know more and we'll share that. So the next thing that I would ask Cameron to talk about is things that we see in doing due diligence, whether we're representing the seller or the buyer. So, we're beyond the LOI phase. We're in the process of, if we're representing the buyer, we're asking the seller to provide to us certain information and documentation so that we can review it. We can match it with what they've told us in their representations and warranties, that all this stuff is true. Here are all the material contracts. Here are our tax returns. We haven't had any tax audits. We haven't had any employee issues. Here's the employee roster, all these things. And so even as soon as, or as recent as about a half an hour ago, I had to send an email. Cam had done a review of some supplemental due diligence responses, and we're still missing a lot of stuff. So now I have to go back to the client and tell them they haven't given us what we needed, and go back to opposing counsel and say, why are you not giving us what we asked for? We've been asking for it for at least a month, and most recently from 3 different people, the broker and from opposing counsel and from the seller directly, and we still don't have this stuff. But a lot of times what we'll see common threads or common themes in doing due diligence reviews of things that are missing, or that, just don't look right. And so we have to ask further questions. So the purpose of this discussion would be, okay, if you're a buyer, things you might be looking for. If you're a seller, things you should be putting into a data room. So Cam, if you want to kind of jump into that discussion.
Of course. And I think a lot of this is going to be more seller focused. I know it's supposed to be both, but most of the legwork seems to be done seller side. So, and that's where most of my advice is from, because that's where I think most of the frustration comes from on the due diligence side in general. I think my blanket statement for people, I think buying and selling, is just be organized. I think their due diligence kind of creates a lot of email back and forth, and things can kind of get lost in the weeds of, hey, I'm requesting these 15 documents. Okay, here's 12, you should be all set. Like, no, there's still 3 missing. Just staying organized. I know we provide our due diligence checklist, which is pretty standard. One thing that we had a deal, I guess, summer of last year, which was great, was buyer had experience in that field. We've provided our, standard due diligence checklist, and they were like, hey, I'm in this industry of, it was like commercial trucking. You wouldn't know this, but there's also this like really niche license that we're looking for, being like interactive with the attorneys and interactive with the sellers as a buyer, and requesting those kind of non-standard documents that may be more industry specific. As an attorney, I'm trying to find those as well and make sure that we get everything. But if it's something that's super niche and it is maybe like not in North Carolina or like document or construct, I might not be super familiar with it. So communication for both, I think, is a huge thing. One that jumped out to me when Jack asked me to be on this panel was kind of having blinders on. I think there's been multiple business owners that we've talked to who have been like, oh, I have no material contracts. My company runs with no material contracts at all, which it might, I mean, maybe they've managed to figure that out. But I think a lot of it is the business owner is so efficient at running their business. They've delegated managing those contracts out to other people, or for lack of a better term, like they've taken them for granted. They don't have to keep up with their copier contract because their copier's been there since 1985. And they just resubscribe every year or whatever. So kind of taking a mental inventory of, okay, I have, a lease and I have a potentially crabby landlord that's not going to let me assign that. So we need to maybe escalate that to the beginning of the due diligence process. So the day before closing, we're not having a moment where, oh my gosh, my buyer is going to be without a property to work out of, or reverse, I as the buyer am not going to be in a property that I need to work out of. kind of escalating issues that you see on the front end as either a buyer or seller. I think anyone involved in that process is going to be really receptive to that. As an attorney, we're trying to do that as well, obviously. But no one knows their business more intimately than the business owner. So having that interaction and communication, I think, is essential. The other one, this was my next one that jumped out, is not having a realistic understanding of how involved due diligence is. It's a very involved process. As someone also running a company and having a full-time job, this is like adding another full-time job to that. Especially if you don't have a organized, like, just file on your computer. If you have like multiple file rooms of documents, or you don't have an inventory of your contracts, you have to track all of that stuff down, it becomes a way more involved process. So I would say don't try to do it by yourself, but then also don't pawn it off on like your office admin, because they also have a full-time job. I think it's something that can be delegated and shared, and then communicated with an attorney, because as an associate, I'm willing to go down and assist with that. I'm willing to go and scan documents. I'm willing to do whatever it takes to make sure that we can get all that information, with the understanding that it is a very involved process. And it's not just an extra hour each day to your 60, 80-hour week. It's potentially another 30+ hour commitment in your week. So just something to be mindful of, and not dumping that all on your favorite secretary who's been with you since day one and may know the company really well, but is also fielding everything else that you have going on. So that's kind of right off of the top of my head. I guess another one that we see a lot is if you know that there's a gap in your organizational documents or minutes or any of that, not bringing that up on the front end. Because if you're selling a company, sometimes they will want all of those to be completely filled out. It's super easy. On the law firm side, it's normally handled by an associate or a paralegal, so it's not an incredibly expensive thing to fix corporate minutes, resolutions, do all of that. But it can delay a closing if it's not brought up in due diligence. So just something to keep in mind. Jack, I don't know if you had anything to supplement to that long-winded answer.
No, that's great. It's perfect. I would say on the psychological side of things, so in going through due diligence, a couple of things come to mind. If you are organized, if you're a seller and you're organized and you're able to fill a data room and provide information, then that I think goes a long way in showing that you have your act together, that you know about your business, that you know what's going on in your business. And I think gives the buyer some comfort in that. And obviously they're going to, believe and verify, they should. But and conversely, from a buyer's perspective, you see organization and you see, okay, good. They know what they're doing, and this is going to be a smoother transaction. Having said that, there's also, I don't want anybody to think that we as professional service providers are not empathetic to a client or opposing party that has just been running their business. And it's not necessarily that they've stuck their head in the sand or with blinders on, but that they just assume that, okay, well, a ladies and gentlemen's handshake 20 years ago was sufficient, and they've been doing that. And a buyer's going to want more certainty in the contract and the contract terms as between the parties. But yes, but there are also those that just, okay, it's just wasn't relevant, and they know it's fine and nothing's broken. And so, yes, I mean, you need to, as on either side of the transaction, as seller, you need to pay attention to and be an active participant in the due diligence. And as a buyer, be a participant in the due diligence. And yes, rely upon your service providers, but it really comes down to, okay, this is an anomaly that maybe you and your industry would readily recognize, and seeing, wait a minute, something's not right here. What's going on with that? Oh, well, they seem to have more warranty claims than as you know, as we might have expected otherwise, things like that. So those are the things that you're looking out for. You know, that this day and age, it is usually done by having a virtual data room, whether it's Dropbox. We have our own secure server that we use for due diligence, and we actually offer it to sellers counsel. We're on buyer side just to make things easier for us and for them. And so there's that process. And so I would say, you know, Adam, anything that you want to add to that topic before we kind of go on to the next thing?
No, you guys did a great job. I just would reiterate, one of the things that Cam said about sort of the time commitment that everybody just forgets about, and the problem that you get into in terms of just settling in for the ride, just to reiterate that point, is, you know, so here's what happens, you know. Jack, love your company. Here's blow number 10. You know, we're going to close in 60 days. It's going to be great. You know, but 60 days, triple that right out of the gate, right? Well, I'm going to need to see the next quarter results before we can get this thing finalized. You know, and you know, if you've kind of taken your foot off the gas, which would be natural because now you just got a second job and you have like, oh, there's been a little bit of decline, you know, in the business. We've got to reevaluate that. Well, of course there's decline. I've been too busy uploading your crap and answering your dumbass questions. You know, like what did you expect? You know, so just that's sort of how the not having your crap together in the beginning, that's sort of how the doom spiral starts. So
Okay.
good topic.
I want to go back to the non-competes for just a moment because I was looking at my kind of notes and forgot to mention, because we were talking about whether or not they were going to be enforceable or not as of September 4th. But another big mistake that employers make is taking a form employment agreement and the restrictive covenants that are in there and just applying it across the board. The fundamentals of an effective and enforceable non-compete are basically two factors. It is time and geography. So the length of time that you're benched or benching someone, and the geography of the non-compete, the radius, whether it's done by, you know, geographical boundaries like states, cities, counties, or within a certain radius or diameter, I guess, of it's usually radius of where the office is, kind of thing. And so many times the non-compete is tailored to the person that is being restricted based upon their duties and their skill sets and things like that. So while it might be appropriate to restrict someone who is at an executive VP level or C-suite level in a certain way, meaning for a longer period of time, maybe a larger geography because they were in charge of regions or maybe the entire United States, versus someone who is not, you know, is geographically located, that would only well, let me take a step back. There has to be a legitimate business purpose in the restriction, and not just the restriction, the parameters of it. So if you were to take someone who has lived in Charlotte, was born in Charlotte, has connectivity in Charlotte, and is doing sales in Charlotte and the surrounding areas, and would not be harmful to the business if he or she went to Florida, because the business does not have a presence in Florida, doesn't do e-commerce with Florida residents, but the non-compete says North Carolina, South Carolina, Georgia, Florida, Maryland, Virginia, West Virginia, etc., just because that's what the form said for the prior person. That's a big mistake. And so be mindful of the fact that each restrictive covenant in an employment agreement should be reviewed or thought through as to what is a reasonable restriction. What is your business's legitimate business purpose in the restriction? And have you gone too far, literally and figuratively, in the geography of the restriction and the length of time for that. Some states will do what's called blue penciling, and if they strike things out with a pencil and the rest of it remains, it makes sense, then they will enforce it in that manner. North Carolina is technically a blue pencil state, but I would not rely upon that. But you will see many of our employment agreements that are drafted with sub paragraphs that would say, within 5 miles from the office location, B, within the city of Charlotte, C, within the county of Mecklenburg, D, within the 13 surrounding counties of Mecklenburg or whatever it is, state of North Carolina, state of South Carolina. So so hopefully a judge could cross out from the bottom up and maintain the enforceability. Other courts in other states would say it either in its current form is entirely enforceable or it's not, and we will completely remove that. So basically invalidating the entire non-compete without rewriting it. So I would say I wanted to mention that because we see that often in the form of either drafting them or having a prospect client or client come back and say, is this enforceable? And then we have to go through this analysis as to, okay, for these reasons, we think probably not, but is your employer going to fight it or not? So sometimes it becomes more of a practical, economical optics thing versus it being actually enforceable or not.
Cool. Jack, we've had a couple things in the chat
Okay.
and Q&A if you want to clear those out.
Yep. Okay. So in the chat, okay, so yeah, I should mention the Corporate Transparency Act and the beneficial owner information. So as we've talked about in the past, there is this requirement in 2024 that you file the the people behind the curtain, the wizard behind the curtain, who are the people that actually own the business, and if it's stacked, ultimately who is the person behind there that is in the stack at the end of the stack or beginning of the stack from your perspective. So those need to be the entities that are formed in 2024 within 90 days of filing for when they come into existence. For any entities that were formed prior to 2024, so December 31st, 23 or prior, you have until the end of this year, January 1st, 2025, to file that report. We will be coming out with some guidance and we will be contacting our current clients. We will be informing new clients of these requirements. I will tell you that the reality is that it's not a difficult process. And so, if you want to pay us to do it, we will do it. But I mean, it's just not economically, it's not what we would charge is more than what you might otherwise do, the time of the value of your time in doing it yourself, because it's an easy process. You have access to the information that you need, and you have your own driver's license, you have your own passport. So that, are things that need to be put into the system. And then you're the one that's going to know if your business has a change that needs to be reported. It gets a little complicated when you have multiple entities that are either affiliates on the same level or parents or subsidiaries, and we're happy to help you through those things. But there is guidance on the website, the FinCEN website, that will walk you through that. So I would suggest you go to there. Like, the similarity or the analogy is to filing annual reports. It's easy to do. So, most of our clients do it themselves. So, okay. Next question. What happens in general with non-competes and non-disclosure agreements when the company declares bankruptcy or closes down? If not subject to any liquidation, can employers take whatever they can get? Can employees take whatever they can get their hands on for their own future gain? So, that's it depends question. It depends on the nature of the bankruptcy. It depends on what happens to the assets of the debtor, and contracts are assets. And then are they treated as executory contracts or not? And so, we could spend a whole day when I'm having one of my bankruptcy colleagues chat about enforcement of executory contracts, meaning those that have obligations moving forward, and then the business is sold or pieces of it are sold, is that enforceable? And, generally speaking, confidential information, or if it remains confidential information, there is an obligation to do that. Now, as far as a non-compete, if the business doesn't exist as it did before, and again, these are very general statements. So this is not advice. This is just my thoughts on a very generic situation that in a bankruptcy setting, that if the business no longer exists and it's being sold off as pieces, then I would think that the intellectual property would still be subject to protection and non-use, but the non-compete, what is the business interest of the acquirer of those assets to keep that person benched? It's different than what the actual business owner, the debtor, is. And so it just have to be looked into. But I would say that, the likelihood of enforcing a non-compete in bankruptcy, and it also depends. I mean, you're talking about the CEO of the company, you're talking about an inline worker or a manager or supervisor. So again, it depends. It depends on a whole lot of different factors in order to say whether or not the non-compete would survive a bankruptcy filing or not. All right. Software license is still a challenge for many buyers and sellers. It's a question, are they? The issue has been non-transferability in some contracts and also having a grasp of the contractual costs, but not disclosing that the license coverage is out of compliance. Licenses extended to far more users than contractually required or to third parties. Okay. I would say that not just software licenses, but any licenses or any contracts are challenges for in a transaction, an APA transaction or a stock transaction, because there are issues of is it transferable? A change in control? Is there an exit for the parties to say, yeah, I'm not going to be providing those services or their goods anymore unless we consent to it? And so the issue of those content, it's just part of the due diligence, as Cam was talking about, which is that would be a material contract that would need to be looked at. And we routinely are advising clients on, okay, this contract says it can be terminated in 30 days, 60 days, 90 days. It's an evergreen. And by the way, it just got renewed on a month ago. And so now you're stuck with it for 11 months. So those kind of things come up. So it really, again, I hate to say it again, but it just depends on the circumstances of what is in writing, and then also the performance of the parties in executing that contract. Does there have to be separate consideration for, what's that?
Oh, we lost Jack. He's back. You're on mute, buddy. You're on mute, Jack.
Sorry, lost all the data in the chat, so it reset. So
That's okay.
I think Joe maybe had a question about.
Yeah, it was around. You have to have separate consideration for a non-compete.
Okay. Again, that depends. The best, and this is also something that gets screwed up, and not because it on purpose, it's just because people are just not knowledgeable about it, which is, so the best way to have an enforceable non-compete, assuming that you have the geography and the time correct, is to put the non-compete provision in front of your prospect employee prior to them signing, prior to the first day of work, and not putting it in front of them in the first 2 minutes of them showing up at the property to have their first day of work. It should be provided them in advance so that they can look at it. They can share it with their legal counsel if they want, or share it with a friend who's a lawyer, whatever it may be, and then come into it and say, okay, first day, here's your employment contract, sign it and be done with it. If that doesn't happen, you have a couple options. One is to, well, really, it's just one. Yes, additional consideration, but how does that come up? It is that you're paying them a signing bonus or some other consideration. North Carolina statute does not say it has to be 10%, it has to be 5%, it has to be a dollar amount. It says sufficient additional consideration. Threatening to fire them or not continue on with their employment is not sufficient consideration. Then becomes an issue as to whether or not they were sufficiently informed that they were going to be under non-compete. A lot of times that becomes the defense is that, well, we had talked about it, but I didn't know exactly that it was going to be 2 years. I thought maybe 6 months. I didn't know it was going to be 100-mile radius. So now that means I have to move out of my hometown that I was born in, grew up in, have all my friends in, have all my contacts in. You want me to leave? That's not reasonable. So you start chipping away at the enforceability of that contract. So additional consideration would be required if you did not just, I guess, simply stated, do it correctly on the front end when they were signing up either the separate restrictive covenant agreement or the covenants that are contained within their employment agreement. All right, any other questions that?
Yeah, we had a chat, and I feel like you're going to be up next week too, Jack, because we got through 2
Yeah.
items. But the Q&A from David, could you address the changes to the requirements for an employee to qualify as salary exempt? There have been changes to who qualifies and who does not qualify. My understanding is that there's also more changes coming in January 2025. So it's actually 2 separate issues muddled into one question. The first question, this is where Jack's going to say, cool, I didn't have to answer that, so I'm not going to lose my license. Do I have an exempt employee or not? Meaning they're exempt from overtime. That has not changed. Like the classification of who is exempt from the overtime rules versus non-exempt has not changed. So generally, someone is considered non-exempt when they're not making decisions, just like as a general rule. But the thing is that people really screw up here is they say, well, the receptionist gets to pick what coffee we order. Thus, sir, yeah, or he could be he. We actually have a male receptionist in our Hendersonville office. Thus, he is exempt, sir. That's not the way it works. I mean, they're generally, like if you follow up the rest of the literature, it's like, and generally it requires, a licensing body to do the work, a college degree or a trade degree, like there's other things that would lead you to believe that somebody's exempt versus non-exempt. So the first, the determination status, if they're not exempt, you owe them overtime, period. Like there's no, there's no bright line on that. So the second embedded question really comes down to if someone is exempt, under what circumstances would I also have to pay overtime? Because what I could do is I could say, yeah, Jack, I mean, you're hired, and then I start the Viking, rowing regime for attorneys down in the bowels of the ship where I pay you rum and peanuts, and you're rowing, 100 hours a week, and thankful that I'm not throwing you overboard. You can't do that either. It's just that the bar used to be so low in terms of what you paid people. I want to say like the before the summer, it was like $38,000 in annual salary or something like that. So most people, they were over the bar. But then they raised that to I think round numbers is about $46,000 right now, but it goes up to $59,000 in round numbers in January 2025. So for people that have exempt positions, which would be in Jack's world, potentially, I don't know how much they pay paralegals, but starting paralegals, this might be an issue with like crap. Either we're gonna have to start putting in an overtime regime or an overtime policy, or alternatively, everybody gets a raise, to be above the threshold. So it is two separate pieces, David and everybody else. And did I screw anything up there, Jack and Cam?
I think you're good. I didn't see Cam shaking her head like in
Yeah, she's like, I'm never coming back
disbelief.
on this before or again, and I seriously need to raise up some issues with risk management about this boatsman character. Being associated with the dude's in his basement, he's wearing a baseball cap and God knows what in the background. Just kidding. Anywho, we are coming up at about 4 minutes left. Is there anything you guys wanted to touch on or save the rest of the stuff for next week?
I think we save the rest of the stuff for next week because it's just it wouldn't do justice. But just to give a little bit of a teaser, some other things that were on my list were talking about loan defaults and relationships with banks, lease defaults and relationships with landlords, or being a landlord. Issues have come up with the tax treatment stated in an operating agreement that doesn't match the actual tax treatment, and would that might blow an S corp election because of what is stated and what's being done. And so we'll chat about that. And then, I was initially impressed, Adam, about the list that you sent to me. I was like, wow, this is well thought out, and how did you get it done so fast? And it's formatted nicely, and come to find out it was Chat GPT, but that's okay. It so some of the things that are on there about choosing the wrong business structure and how that should be considered on very, very much on the front end. Failing to protect intellectual property. I would say that, maybe 15, 20 years ago, that intellectual property really was not as valuable as it is today. It was treated as an intangible asset, and then allocating any value to it in a transfer transaction, an APA or a stock purchase really was non-existent, and banks were not putting value on that and lending on it because they didn't believe that it had value. Fast forward to today, where I've always called it the subliminally overt. What is burning into your retina as you are looking at something that then relates back to the source of the product or services that you are viewing or may acquire. And so that has a lot of value. And if you don't protect it, I mean, it's a, as Cam would tell you, it's a large part of our due diligence process, which is tell us about your intellectual property. Tell us what you're doing to protect it. Tell us about maybe your exposure to data breaches because you're holding information that is subject to federal law regarding securing data. And then if you're operating in Europe, there's all kinds of European laws in relation to that. And then, we've talked about some of the other things, but so we have, yes, a large list of things to talk about for the next time.
Cool. Well, I appreciate it, Cam. Awesome being here. I hope that you are going to be able to join us next week. It's always delightful to have somebody else, So Jack and I are like, yeah, it's like Bert and Ernie. Beavis and Butthead, you kind of pick whatever whatever you want here as your thing. So I appreciate it. And it means I officially get one more week to come up with my top 5 tax mistakes that people make. And as I told Jack, I have already searched Chat GPT. So unless Chat GPT has a different answer when Jack asks the question, which will be an interesting experiment.
That's true. I'll do it.
Just to see what happens. Otherwise, thanks very much, guys. And if you guys have other follow-up questions, just make sure you send them to us and we'll get them addressed in the next webinar. Because chances are, if you got a question about it, then somebody else has a question about it too. So thanks for being on, everybody.
Thank you. Thanks, Cam.
All
Thank you,
right, see ya.
guys. Bye.
All right.